A trademark, a registered trademark, covers all the countries.
The same or the similar name, and the issue is...
Well, brands and trademarks are different.
Oh, thank you. That's really insightful.
So with 10 years of experience in trademarks, I think we've heard all the misconceptions about trademarks.
Yeah, and we wanted to discuss them in the form of a dialogue. So we'll be reading the questions out and responding in terms.
Right, sounds good. Let's go.
Okay, so the first one sounds like if I use it, it's protected.
Oh, that's a tricky one. It's kind of right, but only in some countries. Like there are first-to-use countries, there are first-to-file countries, and if you are in a first-to-file country, you will get some protection, but it won't be like the full protection you would get after registering your trademark. So it will be very expensive to enforce your unregistered trademarks, and you can get into a lot of trouble if you use it without, like if you use a trademark similar to others' trademark. So it's not entirely correct. Right.
Okay, could you maybe comment which countries are first to use?
Yeah, first-to-use countries are usually, where they speak English. Those are first-to-use countries: the United States, Canada, the UK, Australia, and New Zealand. Those are the major first-to-use countries. All other countries are first-to-file. Who files first will get the entire protection, even if you use your trademark first.
Yeah, got it.
Right. Well, I will be reading the next one. Are you ready?
Yeah, let's see what you got.
If I file a WIPO mark, it's international.
Well, what can I say? I mean, WIPO is not some sort of black passport for trademarks. So you have to pick a specific country or list of countries to get your protection of your trademark. Even through WIPO, it's not like a checkbox of all countries. You need to decide and choose and file it country by country.
But it says international trademark treaty, huh? What do you think?
Yeah, I mean, it sounds great, but, it's like selling a dream.
Yeah.
Even trademark offices, they would like to sell you something, to offer you something, and it sounds like the best offer ever, but you always need to, read what's written in like small text.
That's a good response, thanks.
Yeah.
Okay.
So the next one would be, I can add any word to an existing trademark, which is not mine, to make it unique.
Oh, that's a very popular misconception. I hear it a lot. I heard it a lot. And it's incorrect, obviously. If there is a similar trademark and a trademark Coca-Cola, you can't add, like London or the UK or 123. It's not like domains where you can add just a few numbers and create a unique domain. Trademarks have a scope of protection. So if your final trademark with this added word is similar to the prior trademark, you will still get into trouble, especially if the prior trademark is famous. So it's not true. It doesn't work this way. In some cases, it might help, but it really depends. And there are very few cases where this can actually be useful.
What about punctuation marks, though? I quite often hear from clients, like, what if I add exclamation mark at the end of my trademark name?
Well, yeah, it won't change anything. It's still like adding exclamation marks, numbers. Those are not very distinctive matters, so adding them won't help really.
Yeah, definitely.
Okay, the next one. Oh, yeah, I hear this a lot as well. A trademark, a registered trademark, covers all the countries.
Well, it reminds me, of the previous question about WIPO a bit. Well, the answer is no. It's like quite, all the time. I remind our clients that it's like a Netflix subscription. It's regional, it's territorial, and it's protected only there. Like with Netflix, you have certain movies only, in specific region.
Oh, I know this.
Yeah, I suffer a lot from it. So with trademarks, you register your trademark in the US, for example, and it's registered, protected only there, and you can't, file oppositions in the UK or like the European Union and say like, hey, this is my trademark. Yeah, that's your trademark only in the US.
Huh, wow.
Yeah.
So you want to say that you can't use a US trademark abroad? You can't enforce it abroad?
US doesn't rule the world of trademarks.
Okay.
So in order to have, the full set of protection, you need to file and register it in a specific country.
All right.
Yeah, it's possible. It's possible to reference your U.S. trademark, but still, if someone has a registered trademark in another country, your position will be quite weak.
Okay.
Yeah. So let's continue with some other misconceptions, like this one. Trademarks are expensive and are only for big companies.
Okay. Well, I know this misconception. Some new clients, new companies, they repeat this a lot. There is this idea that trademarks are very expensive. They are only for settled-in businesses, for big companies, corporations, and they cost tens of thousands of dollars. And it's actually incorrect. Getting a trademark, depending on your country, can be really cost effective because your trademark will be for 10 years and it can be even cheaper than getting a domain name. For example, in China, getting a trademark costs $300. In the United States, $600 with a legal fee when you are hiring an attorney. So actually, it's not that expensive. And thinking that you get this trademark for 10 years, your cost per year will be $50, $60. It's not much. It's something you can afford. Obviously, there are some businesses which are very niche, which don't have a lot of sales, and probably trademarks can be expensive for them. But for the majority of business, it's not such a burden. You can afford this. Most likely, you will need to find a cost-effective attorney, a budget-friendly attorney. But yeah, it's possible.
Yeah, I remember that one person from our team once said that, like, hey guys, registering a trademark is cheaper than getting a new iPhone.
Yeah.
And I was like, God, yeah, that's true. And people, when people don't think about it, it seems like scary and very expensive. But actually, it's not.
Yes.
Yeah.
And that's
Crazy.
something you will be using every day in your business for 10 years. And that's not that expensive, right?
Yeah, that's crazy.
Okay. Let's move to the next one, right?
Yeah.
I will be reading out the next one. All right. Owning a mark in your home country is enough.
I mean, if you never plan to leave your backyard, or like you plan to stay in that country, and like you don't want to grow your business, I mean, and that's okay. Some people don't have that kind of ambition. And then, it's enough, for example, to register your trademark in the UK or just in the US where you live and where you sell your goods. But most businesses nowadays, especially with, online trade, etc., it's wise to get the trademark at least in the most popular jurisdictions. And I will once again repeat that the most popular are the US, the UK, the European Union, and for some businesses, Canada and maybe Australia.
Okay. Yeah. Well, I have one question about this. One more question. So maybe you can mention, like, if you produce your products in China, what do you need to be aware of? And you sell, for example, only in the UK, but you produce them in China. Can you elaborate about this?
Yeah. So the situation is in China is always quite tricky, just because trademark infringement seems to be so popular around there. All the Chinese companies, startups, and like everyone, they want to use the same or the similar name. And the issue is with the fact that China is the first to file country. So once you file, you have it, and here the issue lies. So if you don't secure your trademark in China, as soon as possible, like as soon as just the thought comes to your mind that I'm going to manufacture or like even sell something in China, go and file it, because it's the first to file country, and you have to grab that trademark for yourself. We all know stories about like similar trademark names, and most of them are either from China or from India.
Exactly. Right.
So the next one would be about explaining some differences within terminology. So is registering a business name or domain name is the same as trademark protection?
Okay. Yeah. Well, this is a popular misconception as well. So registering a business name it's never equals getting a trademark. So a business name protects the name of your company. So other companies can't register the same. Well, so it's not possible to register the same name, the same companies with the same name. And trademarks, they are associated with products and services, and they have a scope of protection. Business names are like domains. If you add just any word or 1, 2, 3 or an exclamation mark, technically you will have a different name, and technically your business name won't cover it. So anyone will be able to add a few letters, a few numbers, and get a similar sounding business name. As it was mentioned before, with trademarks it's different. Trademarks have a scope of protection. So as long as something sounds similar, looks similar, or is conceptually similar to your registered trademark, others won't be able to use this word or logo or something. So registering a business name is not the same as registering a trademark. The scope of protection is much narrower, and it grants you no special rights for this word or for this combination of words.
Actually, you said something interesting about the definition of trademarks, that they're defined, to distinguish goods and services of a certain person or company on the market. And this is something that it's, written in trademark law. But lately, I've been reading more and more about this changing into trademarks being kind of the face of the brand and kind of associated with the word brand. And sometimes two definitions are really intertwined, on the internet. So maybe you could comment about that a little bit, and, about all the good stuff that trademark brings when you do a lot of marketing and like sales.
Okay, so brands and trademarks are different. So brand or branding is a more generic, more general term, which includes different trademarks. It might include different trademarks. It might include unregisterable things such as trade secrets, for example, or your signature colors, which can be registered, as we know, but it is difficult. So branding is like a combination of everything that identifies your products, identifies your company. And trademarks are something more narrow. You have this name, you have this logo, you have this name, this logo in those colors, for example, associated with those products or those services. So it's a very narrow and well-defined, I dare to say, well-defined term. And it can be registered, it can be protected by the government, you can enforce it. And enforcing a brand, which is a very general term, it's very difficult. It's nearly impossible. You will still need to have those objects of intellectual property, such as copyright, such as trademarks, patents, to enforce your brand. or enforce your trademarks, your intellectual property.
Well, thank you. That's really insightful. Yeah, I guess the narrower, the protection, the easier it's to enforce it and maintain it, and well, actually do something with it.
A good example: Apple computers. They have this word "think different," right?
Yeah.
It's a trademark, you know this, right?
Yeah.
It's a registered trademark. So think different is a trademark, it's enforceable. You can prevent others from using this. But the idea that they produce innovative computers, that they are very comfortable to use, that they are very reliable, that's part of their brand, but it's not protectable. Others can say, like, we do innovative computers, we produce innovative computers.
Yeah, exactly. Thank you.
Wow, okay. Let's move to the next one.
Yeah.
So I have two misconceptions here. I think I will start with the second one, with the first one, sorry. So many people think that getting a domain name registered equals trademark protection. That if you have the domain name, you have priority in getting a trademark. Is this so?
So, domain name is specifically for the domain you use for your website. And it doesn't give you trademark protection. It doesn't equal that. There's just, separate things. It's like, apples and tangerines.
Yeah.
They're totally unrelatable to each other. You have to, in the majority of cases, we suggest registering a domain name as well and the trademark. It's possible to do this at the same time, and actually getting a domain name is quite easy. Once you buy it, once you have it, you can register it through the office. Generally, most domain names were registered. I think we had in Andorra. I think we did. Yeah, that's the one.
So maybe you can explain how domain names and trademarks relate to each other. Which is more important? Which type of intellectual property is more important if we compare them as separate types?
Yeah.
Which one is likely to be dominant?
So I would say trademarks. Trademarks are likely to be dominant in mostly everything that you ask me about, and it's not just because I work in the industry. It's also because nowadays it can encompass so many different things for your brand, and it can do so much for you, and it protects not just your goods and services. It helps your marketing, helps your sales, helps not just your physical stores, but it assists in your online business as well. And domain name is just for your website. I mean, it's just one specific thing, and it doesn't. It's not associated with goods or services. It's not associated with the products themselves. I think that's really important to mention here. That that's unrelated.
Okay, makes sense. That makes perfect sense.
Yeah.
Let's go on then. Your question.
Okay, so the next one, the next one is a fun one, I would say, because I hear it a lot. Trademarking is too expensive and complicated. Okay. Well, too expensive. We talked about it, but I think we should, we should mention the complexity of it, so to say.
Oh wow! So if you do it yourself, without any support, and you know nothing about trademarks, it can be complicated. Yeah. So actually doing the entire process yourself without understanding what happened, what might happen, even what might happen, is very risky. And true, it can be complicated, it can be complex. Trademark law is complex. In some countries, it can be even more difficult when you need to prepare a lot of documents. Like the United Arab Emirates, for example, where you need to legalize all the documents and get them signed by the local embassy, etc., etc. So it can be. The good thing is that if you work with someone who understands the trademark law, it won't take a lot of your time. It won't take much of your precious time. You will need to get involved maybe 3 to 4 days to um, 20 to 20 to 30 minutes per day to get the initial information. And that's all. After this, the entire process, which can take up to 1 year, is handled by by a specific specialized team, by specialists, by experts. So I would say like this: if you do this yourself and you don't understand what you are doing, it can be complex, like any task. If I start programming or writing code, it would be very difficult. It will be very difficult for me because I don't understand what I'm doing. But if I have someone who understands, like by my side, it will be way easier. So I would say the key here is find an expert. Find an expert in this industry so he can do this for you. And you simply need to provide the information. It takes literally 20 minutes to get all the information, maybe more. And the expert, the team of experts will do all the heavy lifting for you.
Yeah, that's nice. Could you also comment on the fact that once a trademark is filed, for example, you chose your trademark attorney or trademark solicitor, so you're using some assistance, and then they file your trademark. Is this true that afterwards you need to do nothing, like they do everything, or are there any exceptions when you need to, step in as well?
So if the process is straightforward and there are no complications, usually you don't have to step in. You just receive your notifications, you read them through. Obviously, you need to check what your attorney is sending you. So you check, you see that there are no complications. They will ask you to do something if anything is required, and you will just get your trademark certificate, and your objective is to renew it. I guess we will discuss this later. Usually, the process is straightforward. So in the majority of the cases, the process is straightforward. But there might be complications along the way, you know this. So there can be objections when the trademark office says that something is wrong with your trademark, or there can be similar trademarks. There can be legal disputes. There can be legal disputes.
Yeah,
right.
Cease and desist. They're kind of nasty. You never know if you'll receive one.
So in this case, you need to pay attention to what your attorney is sending you. But other than this, let's hope the process is straightforward. You won't have to do anything. And in some countries, there might be additional fees to pay to register the trademark, both the final fees. But once again, your attorney will inform you if you need to pay them. So I guess this is like a rather complicated question, a lot of ways to respond to it.
But I guess it's still a kind of partnership.
Exactly.
You still participate a bit. React to something what happens, but it's not like you're a super active participant.
That's a good explanation. You don't have to do like daily check your trademark or respond to any emails. No, just once.
Exactly.
Okay, are you ready for the next one?
Yeah, let's do that.
A trademark grants exclusive rights across all industries for all products and services. What do you think about this?
Oh, that's so classy. That brings me to the matter of classes. That there are 45 classes. And trademarks are protected only within classes. So that's the our standard procedure. Once a new client comes in, we tell them that, hey, could you describe what you're doing?
Exactly.
Like product, service. Just like, some clients tell us that, like, hey, we sell frying pans, or like, hey, I'm making popcorn and stuff. And that's the way to determine a class. And then it's protected only in this specific class for these specific products. Of course, you can choose more than one product within the same class or in a different class. And usually your trademark attorney or trademark solicitor, they will tell you if this is the same class or if it's different class because, obviously, additional fees associated with extra classes when filing. But no, like, imagine Nike
Yeah.
like suing a plumbing company because they're using like the same name. No, it's like plumbing has nothing in common with like sneakers and all that stuff. So yeah, no, of course not. If you'd like to get more protection, well, you can choose more classes. But still, we usually suggest otherwise, because in some countries you need to provide proof of use that you actually use this trademark with this set of products or services, and the trademark won't be registered if you lie and if you're just trying to like monopolize the market. Yeah, so
True.
so yeah, get these classes correct.
Yeah, a good response. Okay.
Yes, so the next one would be associated with, some pre-filing
Okay.
actions. If a trademark isn't identical, it's not infringing.
Okay, yes. Well, it's somehow related to one of the previous questions, one of the previous misconceptions. So identical doesn't mean conflicting or confusingly similar. So a trademark must be unique. It must not be confusingly similar to any other registered trademark within the same class or for similar services or products. So if your trademark, if it is not identical to a well-known trademark, for example, it still can be confusingly similar. You still can have problems. Let's say you have your trademark, you want to develop a search engine and you call it Google. It's very similar to Google, and Google will come for you. Trust me, the attorneys will come for you. So it's very important to understand trademarks. They can coexist only if they are not similar. They are not confusingly similar. And checking if there are any similar trademarks is one of the most important tasks before filing your trademark. That's why you need an expert to check if there are any similar trademarks to avoid those legal disputes.
Yeah, that's a nice one, and there are lots of different offers on the trademark search these days. So yeah, I mean everyone has an area like to choose from. So yeah, I mean people shouldn't skip that part.
Yeah, exactly. Even we develop like a free study, free search
Yeah.
for almost all the countries, right? No, we have it in all the countries.
All of them.
Yeah, so it's basic, but still it's better than nothing. We did this because we want to avoid those cases where people just file for trademarks, like Google, the example with Google,
exactly.
and get into trouble. Okay, this one is tricky. You can register anything, any word, any image, or basically anything as a trademark. There are no limitations. What do you think?
Okay, here we're arriving at some restrictions.
Yeah.
Yes. So I think the obvious one would be is that, or I think the easiest to guess for people outside the industry is that the trademark can't be offensive.
Okay.
No offensive words. I can't quote any of them, but I think we all can imagine what type of words are these. And no specific insults to like specific persons. The other one would be that a trademark can't resemble any country's flag, emblem, or even sometimes some symbolic elements for a specific country, those which are well known worldwide. So yeah, also can't resemble famous organizations like Red Cross or something.
Okay, yeah, I know this.
This stuff, yeah. As we discussed previously, we would suggest steering clear from so-called super companies like Apple,
Mhm.
Nike, something, anything at least slightly similar to these names, it won't go through in a trademark office.
Mhm.
Um, well, these are, I mean, the most obvious ones. I think the more complex ones are about distinctiveness
Yeah.
of a trademark, about generic trademarks. So yeah, the trademark can't just describe what you're doing.
Okay.
Like, I'm selling eye patches, and my trademark is eye patch.
Okay.
So yeah, no, I mean, you can't, because you have to come up with a name for your trademark.
Mhm.
That's the main idea, because you can't take the word that everyone needs in the industry
Mhm.
and just tell everyone that, like, hey, it's now mine. No one can use it. Well, what other people gonna do then? You're just, again, it's monopolization of the market, and it's against rules. So yeah, I would say these are the ones that we come across more often. Obviously, one that I would like to mention is cultural background of some
Mhm.
countries.
Okay.
So in some countries, you can't, register something which is related to a religion, something that is sacred for
Mhm.
a specific country with their cultural and religious background. And you can't do that. Once I had a case when a client came to us and they had the logo of a woman, well, quite. She was a bit underdressed, so to
Okay.
say, and the trademark was to be filed in Saudi Arabia.
Mhm.
So yeah, and we didn't file it because, we told the client simply that it wouldn't be possible.
Mhm. Exactly.
Obviously, if they would like to just waste money, we can go ahead. There is no penalty
In trying.
in trying. Yeah, yeah. No one gets hurt here. Trademark law is gentle, but still, it's just the waste of money. So yeah, no.
Yeah. Makes sense. Makes sense. There are a lot of to discuss on this topic. We can dive really,
Yeah.
really deep in many details, but yeah, that's a good response.
Let's switch. Let's switch
Okay.
to something else. Let's say that I don't need a trademark now.
Mhm.
Because I don't have that kind of money now. I will wait till I become a millionaire, or, for example, my startup gets funding,
Mhm.
and then I register a trademark. So, what would you say? Would you say that it's fine, or would you advise against it?
I would say that this is very risky, especially if you want to raise funding, because this is the first question the investors will ask you: what type of intellectual property do you have? And getting a trademark is almost obligatory. They most likely won't fund you until you get until you file your trademark or you get your trademark. They can give you like some small amount, but there will be a condition to apply for your trademark. Truly, no one wants to invest and get into a legal dispute with some well-known company and spend millions trying to secure the brand name. We had many cases in our company where companies just applied for their trademarks and then realized that those trademarks were taken. They waited for too long and they just couldn't register them. So they had the production line, they had the products they were actually selling in the market, and they realized that they couldn't continue selling them.
Mm-hmm.
They needed to rebrand. And rebranding, when you have everything ready, you have the product available, is extremely expensive, I would say. So that's why it's so risky. I think getting a trademark beforehand, when you have profits, when you have at least some sales, and you can afford this, yeah, that's a good strategy. That's a very financially sound strategy to secure it as soon as possible. Because you can just realize that it's not available, and what would you do?
Well, mean, I don't know, cry because the brand I cared for so much and like thought about it.
Exactly.
It's now, yeah, I can't get it. Oh, I mean, that's sad, but we see it all the time.
It happens even with big companies when they have to change names in specific countries.
Yeah, exactly.
Okay. Let me read the next one.
Yeah.
Okay. Well, this one can be difficult to respond, but let's try. A trademark search can be completed online in just a few moments, in few seconds.
Here I'm gonna fight with marketing efforts of some companies that bring that bring what I call false sense of security.
Yeah.
So everyone wants, and I get this. I understand this feeling. As a client as well, that you want to feel secure and you want to feel sure about your next steps with your trademark, about the filing itself. And you want to make it as easy, as quick, as cheap as possible. But it's, not my place to say that it's not how the world works. You have to, usually you have to pay for professionals to assess all the risks, to do a study, and it's not possible to do it within a few minutes or even within like seconds. You need like at least I would say 24 business hours or something. The search can take like 2-3 hours. To spot all the possible conflicts in terms of very similar trademarks, in terms of identical trademarks, and to assess, the general registrability criteria. And I would be careful around, all these aggressive marketing and like all these nice offers that I'm gonna do it like within seconds, like ChatGPT or some sort of AI does it, and like it's easy. Here you have the result. No, the AI is good for some stuff. You can ask some questions, maybe to get some clarification on something, and then, confirm it with a professional or look further on the internet. But you can't rely on AI to bring you, real results. It's gonna be just confusing for you in the future because you will probably get into a conflict with some similar trademark, or, as I said previously, such a quick search can't assess cultural background of specific country and all the possible criteria that we need to keep in mind while assessing a trademark, performing trademark search.
Well, not yet. AI can't do a reliable search. At least not yet.
Yeah, not
Let's
yet.
see in a year.
Not yet. No one knows, but I'm just gonna say that like no, because if we're saying not yet, it sounds like the change is gonna happen really soon. But I think it's not gonna happen really soon. Yeah, there's a lot of work ahead. Yeah, for the engineers and like programmers to do that. Okay, so once we talked a little bit about AI, let's go back to law specifically.
Okay.
I would say. So we talked a lot about the U.S. And the U.S. trademark law. So what would you say? What would you respond to me saying that the U.S. is enforceable all around the world?
A U.S. trademark.
Yeah, U.S. trademark.
Well, you somehow responded this previously that
Yeah.
it doesn't work this way, and a U.S. trademark is valid only in the United States and maybe Puerto Rico, but basically that's all. And you can't enforce it in Australia or in China. They have their own trademark registers. They have their own trademark offices and their own list of active trademarks. So trademarks are very country specific. A US trademark is valid only in the United States. A Chinese trademark is valid only in China. And they can't be enforced like vice versa in China or in the United States. You will need to get a local trademark for this. There are some exceptions to this rule, but they are very few. Basically, those are European trademarks which can be registered in all the countries of the EU. One trademark covers all the EU countries, so you will get this protection in all the countries of the European Union. Also, there is something called the Andean Pact, which includes Latin American countries, and they have this rule that a Chilean trademark can be enforced in Bolivia, for example, or a Bolivian trademark can be enforced in Peru. But that's basically it.
Yeah, it doesn't work in all around the world.
Exactly.
So, yeah, it's only specific countries and specific agreements. Yeah.
Okay, we're getting to the last one. Right, my trademark is totally original. I don't need a trademark search.
I'm sorry for laughing. I mean, I like to joke about this, saying this like these are famous last words right before cease and desist letter arrives.
Okay, exactly.
And like it's just there in your face, very long, and like I actually saw a couple of videos on TikTok about like people opening cease and desist letters and crying over this many pages just because they're like, why did this happen? And that's actually a good example that you shouldn't skip the first step of your trademark search. That's just what we talked about like a few moments ago. And I get the point that you invented a word, for example, for your brand, or you combined some words and create, like, you're being creative.
Yeah.
And you want to protect your creation as if it's your baby. And some businessmen usually treat their businesses and, well, the brand in that way, and the trademarks then as well. But you can't let this misguide you into believing that your trademark is totally original. You can't be sure of that. There are like billions of people out there in the world, and anyone can register the trademark in any country they wish. And, well, what brings you to think that you can be the only person in the whole world to come up with this logo or wordmark? No. Get your search done. Like, be patient. It's very quick. And you'll see for sure that it's original, and I can go ahead with it. I believe that people should have the thought in their mind that if you created something, it's not obligatory that it's original.
Okay. Yeah, and I wanted to remind everyone that there are 10 million of active trademarks in the United States alone.
And they're filed every day.
Thousands and thousands of them. So it's really hard to come up with something truly original, like very original. So a trademark search is almost, I think it's obligatory before starting a new business or starting a new product. Maybe you even have to apply for several trademarks or have a short list of names. Okay, so I think we got to the end of our list and we can wrap up.
Yeah, we did. That was a ride. I'd say it's a lot of interesting misconceptions, but the more I talk to our clients, existing in new ones, I see that time goes by, but people still believe in some of that stuff. and that's sometimes that's alarming even, I would say.
Yeah. It's like you feel that you keep repeating the same words over and
Yeah.
over again.
Oh, yeah. And people are just like, yeah, I heard this for the US, but it can't be the same for the UK or like the EU. No, well, some rules are like kind of universal in terms of
Exactly.
trademark law. Yeah.
Right. So I think we are running out of time. Thank you for the interesting conversation.
Thank you too. Like it was really fun. I enjoy discussing this stuff.
Me too. It was a lot of fun.
Yeah, and I hope that everyone who watches this, this or even some parts of it, finds something new for them, something interesting, and something to learn from. To use while applying for a trademark. Or even making a decision to think of a brand name first, and if anyone would like to continue this conversation with us or file a trademark or something, we're as a company Bonemark, we're here to help with just any sort of question. I think everyone now sees that we heard a lot of them, and there are even more on the way. So yeah.
Exactly. And there are like country-specific misconceptions, like more logo-specific misconceptions, etc. But we actually, as I said, we're running out of time. So thank you a lot once again for the conversation, and let's discuss this again.
Thank you.
Thank you.
Bye.